Welcome back, ladies and gentlemen. The next section will look at the theory, practice, and hearing of an application for early dismissal from arbitration practitioners and arbitrators' perspectives. The moderator will be Mr. Gary Bourne, President of SIAC Court of Arbitration and Chair of International Arbitration Practice Group of Wilmer Cutler, Pickering Hale and Dorr LLP. Mr. Bourne is the Chair of the Teaching Faculty. The teaching faculty members for this segment are Ms. Blossom Hing, Director of Drew and Napier LLP, Director of Drew and Napier, Mr. Luong Van Lee, Partner of Global Vietnam Lawyers, Mr. Mark Mangan, Partner of Dechert LLP, Ms. Smitha Menon, Partner of WongPartnership LLP, and Mr. Abraham Vergis, Managing Director of Providence Law Asia. Mr. Bourne, please.
Thank you so much, and I'm delighted to be here this morning with you, this afternoon, as the case may be. And we have an all-star panel here to look at questions about early dismissal. And perhaps if we can all turn our videos on, if the panelists could turn their videos on, that would be great. I'm seeing a message, unfortunately, that says nobody can turn their video on. In which case we will start in flexible fashion without videos. Here we go. Welcome all. With that little technical hiccup to get our adrenaline flowing after a coffee break and so forth. Why don't we begin? Let's address as if we were an arbitral tribunal. Hello, Blossom. You're with us as well now. Good morning.
Hi.
Why don't we address, if we can, the sorts of factors that a tribunal would look at in trying to decide whether or not to permit an early dismissal application. No particular order, perhaps alphabetical makes sense. We can begin with Blossom and then Mark and move along.
Sure. Well, since I'm a B and Abraham is an A, I will nominate Abraham to start first.
I was looking at the last name, but and I'm the moderator, so I get to decide.
Okay. Sorry. What factors the tribunal will look at to decide to allow an early dismissal?
Exactly.
Well, I think
tribunal, one of the parties, the claimant, wants to dismiss what's an obviously meritless statute of limitations claim, defense on the part of the respondent. What do you as a tribunal member think about in deciding whether or not to permit such an application to go forward?
Okay, I'm assuming we are going on the not the discretionary rule under Order 29.3, but under Section 29.1 instead. So I'm going to start with 29.1 first.
Okay.
On the 2 points, you would first have to meet the test of being manifestly without legal merit or manifestly outside the jurisdiction of the tribunal. I think between the two, the second one is an easier test to meet because as a jurisdictional issue, if, for example, whether something is time barred, or whether something is arbitrable, or whether something just doesn't comply with the preconditions in an arbitration agreement. For example, the need to have negotiations or amicable settlement talks first. You haven't met those preconditions. I think that's easier for a tribunal to look for to see whether to allow the early dismissal application. I think when it comes to whether it is manifestly without legal merit, it's a little bit trickier because you then go into legal arguments, which could also run into factual questions. And then it becomes a question of, well, whose facts are correct? Because invariably each party will say, my version of what happened is accurate, and is the correct version. And as a tribunal, you then run into problems of which version should I go with. I note that the SIAC rules are slightly different, for example, to exit rules. Well, not so much the rule itself, but if you go under exit, I think there is a case where, I have the name somewhere of the case, but where if there is a dispute on facts, you would resolve it in favor of the claimant. And I don't think there is a similar case that applies where it's an SIAC arbitration.
So where you would start, Blossom, in deciding whether or not to exercise discretion under 29.3 would be back in 29.1, you'd look at whether the two substantive prongs of 29.1, manifestly without the jurisdiction of the tribunal, manifestly without legal merit, were satisfied. And that would influence your thinking about whether to grant the application.
I would say so, because there's no clear guidance on 29.3, and it's great having you here as the moderator, because you might be able to shed some light on what we're supposed to do with 29.3. Do you look at 29.1, or is it a very widespread discretionary kind of power that is given to the tribunal?
That's a great question. Even though as president of the Court of Arbitration of SIAC, I'm not the one who applies the standard in Rule 29. It's the individual arbitral tribunals. So I would have to take off my president's hat, have to take off my moderator's hat. I would have to take off my, oh, I just woke up this morning hat in order to answer that question. But in good law professor style, let me say that's a good question. Mark, what do you think the answer is?
Thank you, Gary. I think the answer to the question as to the difficulty of satisfying these tests, if it could be put that way, is that focusing on the word manifestly, and I think there is some authority to support the proposition that that means clear and obvious. And one of the thoughts that occurs to me is that if someone is presenting an application that is overly complex, that is dependent upon witness evidence, extensive legal argument, then I think automatically you are crafting an application that's not manifestly clear and obvious should succeed. So I think when conceiving whether or not to make an application, one has to focus on its simplicity. And if it's complex, and I know this fact pattern to a degree might suggest one could introduce witness evidence, for instance, that suggests to me that it's not going to be clear and obvious. And if judgment calls have to be made on the veracity of witnesses or complex legal analysis is required, then it's probably not going to satisfy either one of those two prongs.
So two observations that Mark makes following up on Blossom's focus on 29.3. Number one, if there are disputes about the facts, witness evidence, but perhaps also even document evidence, authenticity of documents, when documents were sent or received, then 29.3 appears problematic. It requires that they be manifestly without legal justification or merit, as distinguished from evidentiary or factual. And then secondly, even assuming that what you've got is effectively agreement about the facts, or you can assume the facts against the applicant, assume that you resolve all disputed factual issues against the applicant who wants early dismissal, and it nonetheless says there wouldn't be a claim or there wouldn't be a defense on even the facts that the opposing party claims are true. If that would be a complicated legal defense, if it wouldn't be clear-cut, if it wouldn't be straightforward, then again, Article 29.3 would be problematic. We're still note for those in the participants other than the panelists. Note that we're still thinking about Article, the two requirements in Article 29. We're not in the discretionary phase of whether a tribunal decides to permit an application to go forward. Rule 29 is meant to make life simpler, but you have to pay attention to its structure because it can be a little complicated. The party doesn't have an absolute right, a right in all circumstances to present a Rule 29 application to the tribunal and have it heard. A tribunal has to decide as a matter of its discretion that it will allow a Rule 29 application to go forward. I think Ms. Menon is next if we use my somewhat peculiar alphabetical order approach. Smitha, what's your take on how a tribunal should exercise that discretion we're talking about?
I was going to go with the opposite and go with low-lying fruit first. So rather than
go for it.
rather the difficult thing about the test, I mean, what I would do first is try and hope that there were other bases to knock it out or determine whether or not to proceed. So I think Blossom mentioned some of it, whether it's arbitrable, the subject matter, so on and so forth. But I think there are a few other small things that you could look at. For example, timing. Is it too premature? I mean, if parties have not filed their defenses, their reply or a defense to counterclaim, you can't really say you've seen the full sort of case that's set out, or at least the high level case that's set out from both sides. Whether it's too late, because there is a time limit provided for under Rule 29, so that's one basis. The other would be to look at the procedure that would be needed. So the nature of the application, if it's just going to be one defense or one particular material issue or two material issues, it's a bit easier to decide. If it's the whole case, then you have to go, unfortunately, to the higher level of assessing the test and so on and so forth. But if it's the whole case and the procedure is going to involve, a fact-intensive inquiry for parts of it, then it makes it a bit harder. I know in the Travis Cole case, they looked at a hybrid procedure where they had limited cross-examination. So, I think if you work backwards from timing and procedure, it makes it a bit easier to decide whether you want to allow the application in the first place before even getting to the standard of manifest, whether it's manifestly outside the jurisdiction or there's manifest case made out.
That's a great observation. Why don't we stay with it for a moment? Rule 29 is usually referred to as early dismissal, but you're saying that there can be times when it's too early. And explain a little bit more why you as a tribunal member would conclude that it's too early for early dismissal.
Okay, so if the respondent files it even before the statement of claim, I think that's too early. You don't even know what the full case is. Likewise, if the claimant strikes out any defense to counterclaim, I think that's also too early. At the very least, I think the parties' cases should be set out because you're going to go through the process and then the parties are going to raise all the tribal issues. And then, it doesn't save you that much more time if you had just waited for a few weeks and told the parties try and apply in a few weeks' time.
Yeah, it's curious though, right? Because if I recall, Mark will correct me, but if I'm wrong, but if I recall, the ICSID rule requires that your application for early dismissal be made 45 days from the outset of the case, which in many circumstances will be before the real statement of case, before much by way of elaborating the party's case has been. Suppose that the claimant has asserted a cause of action as well as made a number of factual allegations. And if you take those allegations to be true, then under the applicable law, there's no possible basis for the claim, either because it's time barred or because it's a contract involving a different party. Why should you wait? The statement of case can, especially if you put it together with witness statements and so forth, can cost a fair amount of money. Why should you wait in those circumstances?
because one of the tests is...
Or is this not a black and white rule?
Oh, no, I mean, I was thinking from the first limb of the test, where it's not about manifestly out of jurisdiction, but manifestly without legal merit. So, I mean, just looking at drawing a parallel with the summary judgment procedure, summary judgment in court proceedings, usually you'll find that if you do it before you've even seen what the party's defense is, all sorts of tribal issues will come out. And I do think it's too early before both sides have at least set out what their case is. So, I mean, that's just my take. I think it'll end up being, the tribal issues will come out. There will definitely be tribal issues if you don't wait until you see the statement of claim in the defense. I mean, that's my sense of it.
Panel, Blossom, Mark, reactions on when is it too early to seek early dismissal, or is it never?
I would be happy to offer a view on that, Gary. I can see Smitha's point that there will be times where it's necessary to wait until the parties have set out their cases before one can draw these types of conclusions. But I also think on other occasions, it will be apparent from the request for arbitration that it's deficient. And I think you run the risk of, if the application is made too late, that it falls foul of something that's referenced in 29.1, even before those two prongs that you've referred to, Gary, which is the word early. And back to my thesis, I think for these applications to stand a good chance of success, then they need to be clear and obvious on their face, the application itself. And a notice of arbitration, for instance, might raise claims that there's a clear answer to them. They are time barred. They reference the wrong arbitral tribunal, for instance. The predicates to arbitration under the contract have clearly not been satisfied, which is an issue that arises in our case today. Those things you can tell immediately, I would have thought, often from the request for arbitration. And in those circumstances, I would have thought an application could be made. Of course, it could be met with a defense that complicates things, and that would be a good tactic for the claimant to try to resist this type of application, is to immediately introduce a level of complexity, which means the issue can't be determined. So for instance, friendly consultations, to immediately start talking about the types of meetings that there were, or alluding to some type of interaction that then turns on witness evidence, which in turn makes it more complicated to decide upon on a manifest basis at an early stage of the proceedings. So I agree with Smitha for some cases, but I think others, these applications could perhaps be made at an earlier juncture.
Let's look at the sort of reverse question, not when an application might be too early. For example, because the parties haven't had an opportunity to lay out the legal basis for their respective cases. Instead, let's look at when an application might be made too late. What would be the considerations that go into a tribunal's assessment of whether or not an application is too late? Mark suggests that there's something in the word early that requires that an early dismissal application be made, not surprisingly, earlier rather than later. But what is that right? The SIAC rules, unlike the ICSID rules, deliberately eliminated the 45-day requirement. In doing that, they didn't put in any other requirement. Is there some sort of rule that prevents a party from seeking early dismissal late, not early in the proceeding, say just on the eve of the hearing? And if there isn't such a rule, are there circumstances where early dismissal might make sense?
The whole purpose of the rule is to save time and cost, right? So I think if you leave it to too late, then it really is, what's the point of going under the rule? You might as well go and run through the whole arbitration yourself. It's just an instinctive reaction to timing issue.
Yeah. Abraham, I think you're next up in our alphabetical march.
Yeah. I think it's significant that Rule 29 does not stipulate a period within which such an application has to be made. Neither a starting period nor an ending period. And therefore, in theory, application under 29 can be made at any time. That's my view. Having said that, the longer you take to make the application, the less the argument in favor of entertaining the application, because the tribunal may not see any savings in terms of cost and time. And the obvious question arises as to why this was not taken out sooner if there was a manifest case for either lack of merits or lack of jurisdiction. I can, however, foresee circumstances where in the course of the development of the case, they may come to the attention of one of the parties' facts and circumstances, which now gives rise to a legal objection which was not previously known. And in those circumstances, one will imagine that a proper case is made out for an early dismissal application to be heard, even though it was made quite late in the day. So in summary, I think it really turns on the facts and circumstances, and particularly whether the applicant can justify the late application for early dismissal.
So those would all be facts and circumstances that would feed into the tribunal's exercise of its discretion as to whether or not even to permit the application to go forward. If a party comes forward late with no good reason for having not come forward before with an early dismissal application, a tribunal needn't even permit the application to be heard.
Yeah, I think it is a balancing test that the tribunal needs to undertake. If at all relevant, I think the fact that some water has gone under the bridge would actually help to clarify the facts and circumstances to the tribunal so that the merits or lack thereof of any application can be more easily assessed the further down the line you go.
What about I think it was Blossom who made the observation that if you wait until later in the proceedings, say, in my example, the eve of the hearing, you won't really save time and money by hearing an early dismissal application. Arguably, by letting it go forward, you'll waste time and money because parties will spend money briefing that as well as everything else that they're doing. How might an early dismissal application save time and money if it were made, for example, on the eve of the scheduled evidentiary hearing?
Yeah.
Sorry, I was going to jump in there because I actually wanted to raise it after Abraham said it. I think that the beauty about the rule not having a time limit shows that it accommodates all types of situations. So on your question about how can it possibly save time before the hearing, just on the eve of the hearing, how about a situation where there's a new case that comes out that makes it very clear what the legal position is in the governing law? And that does run through a lot of the planks of a party's case. Then I think it makes a lot of sense for that to be heard first, almost like a preliminary issue, but you have an early dismissal on that basis. So there could be situations, I mean, jurisdiction is one where I fully agree with Mark and Abraham that maybe you start thinking in terms of Rule 28.3 timelines. You know, it's as early as possible, nothing's going to change. But for issues like where the law may change or where new facts come to light, which would really change the whole complexion of the case, then I think early dismissal, the fact they can do it at any point in the process, serves a very important purpose for time and cost efficiency.
But how, if you were on the eve of the hearing, would you save time and money? What would be the point after everybody spent all the money preparing their witnesses, filing their statement of claim, statement of defense, statement of rejoinder, statement of rebuttal to the rejoinder? Think how much money's been spent then. Why would you save any money if you sought early dismissal when actually it was a quite late dismissal?
Because you wouldn't have to sit through the full arbitration. If you can determine on a point of law that a lot of the claims fall away, your 40-day hearing becomes a 2-day hearing or a 3-day hearing. I mean, basically you on the eve of hearing, you're changing your case. Or you're forcing
you saved the cost of the hearing effectively, as well as the distraction and burden of the witnesses attending.
That's right.
Luong,
I mean, my point was just that it's flexible. and it has its use, and we shouldn't be so quick to prescribe that early means early. To me, early just means without the full trial, without the full hearing on the merits.
Should we amend the rules? Should we get rid of early? Should we just say summary dismissal as opposed to early dismissal or late dismissal or medium early dismissal?
I feel like that's a trick question, so I'm going to pass it on to the answer.
No, it was completely honest, open, transparent question. We're about to start, as you all know, our new rules revision process, and we're taking all sorts of observations. Luong or Abraham, any thoughts about these issues? How a tribunal should exercise its discretion in determining whether to permit a Rule 29 application to go forward? And is it really early dismissal that we're talking about, or is it instead something like summary dismissal?
Well, hello?
Yes, by all
Yes.
means.
Actually, I think maybe early dismissal is has become a common term used to to qualify that kind of action and that kind of application. But in reality, the adjective early does not have much significance to me, particularly if we consider clause 29, rule 29 of SIAC rules, because as Abraham said, there is no timeline for submission of an early dismissal application, and therefore the tribunal, as a matter of principle at least, is not allowed to reject or not allow an early dismissal application to proceed just for the reason that the application has been submitted too late. Even on the eve of a hearing on the merits, Rule 29, would not allow it. That means, in principle, the tribunal has an obligation to consider the early dismissal application and to apply all the tests prescribed by clause 29. Now, I think on the applicant's side, be it the claimant or the defendant, submitting an early dismissal application at a late moment, for instance, on the eve of the hearing, may be a tactic, to buy time. Very often in arbitration proceedings, having more time, be it just 1 week or 15 days, for instance, is very important and may be very significant for the party. I said I use the word tactic because normally we would think that there is no particular reason why the claimant or the defendant would submit the early dismissal application at so late a moment. But who knows? Sometimes it may be, as I said, useful for the applicant. Thank you.
So what about the proposition that Luong sort of alluded to, which is that a tribunal must hear an early dismissal application? I guess if I were in a party's position wanting my early dismissal application to be heard, I'd say, if you don't hear my application, I'll be denied an opportunity to be heard. It's self-evident. Hear my application for early dismissal, even though it's actually application for late dismissal. And even though you might not save so much time and money, you'd save some, and I have a right for you to hear my application for early dismissal. What's wrong with that argument, if anything?
I think the wording of 29.3 to me at least suggests that the tribunal has the right to not allow it to proceed. I mean, that's what it says. So I think that's where the balancing, that's where it balances out the timing point. Because there's no timeline for when you must make the application, I thought that's why 29.3 says that the first level is for the tribunal to even decide entirely within its discretion if it even wants to hear the application. So I thought that's where the balancing exercise came in.
Yeah, I think most tribunals have looked at it in that way. And we've been talking about a variety of the facts and circumstances that might be relevant to that exercise of discretion. But why can a tribunal decide it doesn't want to hear an application? I mean, don't parties always have a right to have their application be heard? Aren't they being denied the opportunity to be heard?
So for me, 29.3, the discretion that is conferred on the arbitrator is really a discretion to balance, two competing values, as it were. On the one hand is the party's right to due process and the right to be heard and to make a full presentation of its case. And on the other hand, it's about saving costs and time and convenience for the parties. So for me, 29.3 represents the balancing of the tension between those two values. And that's really what one is looking at as an arbitrator when exercising the 29.3 discretion. And that is where I think Mr. Luong's point about whether or not it appears on the face of it from the circumstances that the application is abusive in nature, whether it's done for an improper motive or purpose, and whether it's more tactical than substantive. Those are factors which I think comes directly into consideration when a tribunal is deciding the 29.3 point. And so coming to the question of applications like this being made on the eve of the hearing, speaking for myself, if I were sitting as a tribunal, I'd be very interested to find out from the party why they had chosen that late time to launch that application. And unless they've got a really good reason for it, my tendency would be to say that that application will be subsumed within the main hearing. Not unlike in the case of challenges to jurisdiction, which, under some rules, the tribunal can either decide that as a preliminary issue or may choose to postpone it to the end and decide that as part of the award on the merits. That is the sort of discretion which I think should be allowed to a tribunal in a case like this, where he's not saying I won't necessarily refuse to decide this, but this is something which can probably be dealt with as part of the main hearing and decided at the end in the course of the final award. And really the question there will be, as I said, whether or not the party who was applying late could justify the delay. And secondly, the consequential prejudice to the other party or the responding party who may risk losing a tranche of hearing dates, which, going by most of our experience these days, is quite a precious commodity that you don't willingly give up too quickly.
Note that the decision to not allow an early dismissal application to go forward is really a quintessential procedural determination, a decision whether more time and money will be saved by having that application or not permitting it. Oh, oops, we've got another participant.
I just want
and the party isn't losing the opportunity to present its defense, its statute of limitations defense or whatever other defense it might be asserting in an application to dismiss a claim. It's simply having that considered with the merits of the case. Let's stay for just one more moment on this question of why a party might choose later in the case instead of earlier to seek early dismissal. What sorts of things might happen, one that would justify an early dismissal application? One possibility would be there's a change in the applicable law. There's new legislation that for some reason would apply to the case, new interpretation of the law. What other things might occur? Why might a party only, when it comes, to use my worn out analogy or hypothetical, why might a party wait until the last minute before the eve of the hearing to seek early dismissal?
One example that
Awesome.
springs to mind. Yep.
Go ahead, Mark.
Okay. Well, just picking up on the example of a change in the law, the change in the status of the claimant, there could be a change in that status, such as their title to the claim could change through restructuring of the company or the assignment of rights, which might only be determined later in the arbitration.
Well,
one example.
For me, speaking for myself, if I was the arbitrator and an early dismissal application came in very late in the day, I would definitely look at it with great skepticism and think that it is really more of a tactical ploy rather than anything that has merits, particularly in light of the fact that the threshold is so high. So I actually struggled to think of what could actually give rise to a late application for an early dismissal claim. So I think that if you are going to make the application and you make it late in the day, you run the risk of really looking bad, that this is in bad faith or some kind of tactics as opposed to really a genuine case based on merits.
One example would be late discovery of assignment of a cause of action, so that the responding party has just discovered that the plaintiff actually no longer has title to sue, and is raising that objection on discovering that fact, maybe through external circumstances.
Yeah, we might broaden that up as well, right? One could imagine numerous facts being discovered during the course of the proceedings, either because of disclosure on the one hand, or because the other party affirmatively puts those facts into evidence, saying that in its view, they support some element of its case. But the applicant's view make out some other perfectly valid defense, which wasn't necessarily previously apparent on undisputed facts. The same thing might happen by way of a party affirmatively conceding or asserting certain facts. And if we go back to the basic requirement for Rule 29, that it be manifestly without legal merit, if the factual assumptions, in a sense, have changed over the course of the proceedings, as we know they all can, parties introduce new facts, amend their claims and so forth, then there may be a reason that didn't previously exist for a party to seek early dismissal. What is meant? What do we think it means?
Gary, on that point,
sorry, Blossom, go ahead.
At Smitha.
No, sorry, Smitha.
No, I was just saying that the way you framed it is actually very similar to how the Stockholm Chamber of Commerce has framed this rule. So where in the Stockholm Chamber of Commerce Article 39, which is about summary procedure, they've put it as your request for summary procedure could include certain assertions, and one of the assertions they specified was an assertion that an allegation of fact or law material to the outcome of the case is manifestly unsustainable. So it's exactly what you just said. Something could have come out in the document production, or facts could have changed, whereby as a plank of your case, it makes it your claim unsustainable. So just saying, I mean, that really, I thought, made the point very clear, the way it's set out in Article 39 of the SEC rules. Sorry, I didn't mean to interrupt.
Difference between the SEC's approach there and our approach, the SIAC approach. What does it mean for a factual assertion to be manifestly unsustainable. Is that the same as without legal justification?
No, it's an assertion that an allegation, whether a fact of law, that is material to the outcome of the case, that is manifestly unsustainable. It's no longer sustainable. So I look at that as an underlying plank to your case or to your claim or your defense. With that aspect gone, like Abraham's example, and I think Mark also made the same point, that the party no longer has good title, or there's something that, so that would be an allegation of fact that would be material to you being the claimant. And so that does affect the outcome of your case. It makes it manifestly unsustainable.
Let's think about a factual circumstance where, or a hypothetical where there might be a factual allegation, an allegation of fact critical to one party's case that becomes manifestly unsustainable, and think whether it would be permitted under our rule, early dismissal rule. Suppose, for example, the claimant's case is that there was an oral agreement at a meeting that was held, an in-person meeting that was held, not a Zoom meeting, that was held on a particular date between particular people. And suppose during the course of the arbitration, it becomes clear that there wasn't a meeting in person with those people, that a key decision maker on one side or the other really looks like she wasn't there. Question, is that the sort of thing you could get early dismissal on under the SEC's rule? And secondarily, could you get early dismissal under our rule, which deals with claims that are manifestly without legal merit?
Well, I was going to say, I don't see why not. I mean, the SEC rule and the SIAC rule isn't different. It's just that the SIAC rule is less prescriptive in a way. The SEC rule gives a lot more examples of the kind of circumstances in which early dismissal would be applicable. So they give the specific example where, you know, an allegation of fact or an allegation of law that's material has, you know, is no longer, well, it's manifestly, the outcome of the case changes. So it gives you that idea, but I don't think it changes. That's within the ambit of the SIAC rule as well. It's just that I feel the SIAC rule doesn't spell it out, which is a good thing, because I think too much words in the rules is overly prescriptive, and it's good the way it is now, because then you've got all this room, and the point is still manifestly unsustainable. So coming back to your example, yes, if the entire case or claim turned, if the parties' claim turned on how this oral agreement was only made at this meeting and nowhere else, and it turns out that this meeting did not take place, then yes, that is an allegation of fact that is material to the outcome of the case that would make the case manifestly unsustainable, the claimant manifestly unsustainable. And that would apply whether it's under the SIAC rule or the Stockholm rules.
Other thoughts about that?
Yeah, I would offer a thought, if you can hear me, Gary. My connection keeps breaking up a little though.
Yeah, we can.
I would just, I think that there's a theoretical possibility that the claim could be dismissed in these circumstances. But for my mind, at least the particular example that you've posed, it's more theoretical than practical. And that's because the application for early dismissal obviously is going to get resisted by the claimant, and claimants generally would have other ways of presenting their case beyond the particular factual matrix that you've referred to about a particular meeting. Presumably, they'd be running all sorts of alternative arguments in estoppel and implied agreements and so forth that would enable them to pivot away from dependence upon that meeting. So I'm obviously focusing on the specific example that you've given, but on a practical level, I think often with these applications, it won't be as simple as just being able to exercise like a narrow incision into a claimant's case and say, on that particular point they fail, therefore the whole case must be dismissed. Normally, these cases are presented in multiple ways to counteract this. And even if they haven't been presented that way previously, they will be, the claimant will adapt and pivot as a consequence of this type of argument, I would have thought. And one last point, Gary, if I may, is we talk about, and it's a related point, we talk about the opportunity to be heard referenced in 29.3. I think tribunals, again, thinking practically, would be worried about depriving the claimant of an opportunity to be heard across the whole spectrum of its case. And the later that you go into the arbitration, to accept a contested application for dismissal on a narrow point, when the claimant is no doubt arguing hard that there are other ways in which they're presenting their case, and this is a narrow incision that they're attempting to make that doesn't actually dispose of it, I would have thought tribunals would be very reluctant, for fear of prejudicing their own decision, to ignore those protests late in the day and allow the application to go ahead and for a dismissal when there's possible other ways in which the case could evolve in a full merits hearing.
And I just add that under 29(1)(a), you need to show that the claim or defense is manifestly without legal merit. And so the question there is whether these sort of factual discrepancies can sustain such an objection. And I would preliminarily say ordinarily it shouldn't.
And that would be because if you have a dispute about what the evidence is, ordinarily you'd want a hearing to resolve that dispute. You'd want to hear the witnesses who said somebody was at a meeting or not at a meeting. Perhaps that's a bad example, but if there's a pleaded dispute about who said what to whom or what the facts were, then resolving that in an early dismissal application, almost certainly without an evidentiary hearing, is problematic.
Yeah.
Mark makes another point that's interesting. Suppose the early dismissal application is for part but not all of the case. Suppose the claimant has 3 claims for breach of contract. You breached Article 2, Article 3, and Article 4. And then there's an early dismissal application to get rid of the middle one, the claim for breach of Article 3. How does that play into a tribunal's decision whether or not to permit the application to go forward?
I think timing. So if it's early on in the proceedings, then it has more weight because you're narrowing the scope of the case. But if it's like Blossom's example in the eve of trial, then I think it makes no difference. And there's less case management efficiency reasons to want to have the hearing, to allow the application, I mean.
I guess it's also a question of how much overlap there is in terms of the background facts and circumstances that you would need to address each of those clauses. If there's substantial overlap, there's an argument that it's probably in everyone's interest to just deal with it in the round in the main hearing.
The question again would be a discretionary question as to how much time and money would really be saved by hearing and granting the application, even if it were successful. We've got one question from the audience. What's the difference between an application for early dismissal based on a lack of jurisdiction on the one hand, and for the lack of any legal basis, any legal merit on the other hand? Is there a difference? And subsidiarily, what's the difference between an application for early dismissal on jurisdictional grounds and any application to dismiss on jurisdictional grounds as a preliminary matter? How are these different procedural devices similar? How are they different?
I think if we are comparing the two, here manifestly is a red herring, because under 28.3, if you exceed the jurisdiction, you're outside jurisdiction. Whether you're manifestly outside the jurisdiction or just 1 tour out of the jurisdiction, you've exceeded the jurisdiction. So to me, in that sense, there's no difference. Though I can also see an argument for why people get hung up on manifestly, because it is established, at least under the ICSID jurisprudence, that that's an extremely high threshold. But to me, I don't think there's a difference between two.
Why does Rule 29.3 require that a claim be manifestly outside the tribunal's jurisdiction when, as Smitha says, any claim that's outside the tribunal's jurisdiction can't be heard. Why does Rule 29 impose a manifest requirement?
I was hoping you would answer that for us today.
Well, I would argue, consistent with the positioning I've been adopting over the last 50 minutes, but I think this is just reflecting the richness of arbitration, that there are different points of view, and we can all adopt different positions, and on a different day I might take a different position. But on this, the thesis that I've been presenting today is one of 29 being directed towards the early disposal of claims and defences. And I think in that sense, the reference to manifestly is logical, because it's a suggestion that at a very early stage you could dismiss the case on jurisdictional grounds, because it's just so obvious that has to happen. Whereas in 28.3, with the absence of manifest, a dismissal on jurisdictional grounds could happen at any stage, and that would be after a full exhaustive consideration of the issues. But I think 29, for my mind, 29 is directed towards a situation where it's more obvious, such that it can be done more swiftly on a summary basis. And I think often early, although I think we've also established today that there would be exceptions to that because of evolving facts and law during the case, that led to a new objection being able to be made later on. But ordinarily, I think manifest goes to the timeliness of the application as well.
I would just add to what Mark is saying, that the fact that 29.4 envisages that the entire process from the start of the making of the application to the issuance of the order or award on the application is to be concluded in 60 days. That very short time to get all of this done suggests that it has to be a very clear and obvious case before the tribunal will go down this road. So the 60 days now is an indicator of the high threshold of clarity that's required before any order is made on this sort of application.
It's important to remember that Rule 29 deals with what's effectively a summary procedure. It's reflected in it being early dismissal. It's reflected in the timeline. It's reflected in the tribunal's discretion as to whether or not even to permit it. And perhaps the reason for the manifest requirement with respect to jurisdiction is you oughtn't to dismiss on jurisdictional grounds after only a summary procedure, unless you're quite sure that such a dismissal is warranted. This is not, and going back to the question we were asked by one of the participants, this is not like a bifurcated jurisdictional phase to an arbitration where you would have witnesses and full briefing. A bifurcated jurisdictional phase, assuming you're not in an expedited procedure or arbitration, could well take many months. It could take a year if there were disputes about the facts. Here, we're on a fast timeline seeking early dismissal on jurisdictional grounds, and that summary procedure the rule contemplates will only be used when it's quite clear there is no jurisdictional base. Recall, of course, also that the party that's resisting on jurisdictional grounds is also able to argue to the tribunal that the case should be bifurcated, that the jurisdictional objection should be heard as a preliminary matter before you spend the money on the merits of the case. And that is a procedural device, picking up on Mark's comment about the richness of arbitration. That's a procedural device that lies in between early dismissal on jurisdictional grounds and putting jurisdiction together with the merits of the case and hearing everything at a final evidentiary hearing. We've only got time for a couple more comments. Is Rule 29 even necessary? Doesn't a tribunal have the discretion to dismiss claims, hear claims on a summary basis and dismiss them if they're manifestly without legal or factual merit? Couldn't a tribunal do that anyway? Why do we have 29?
I think in Singapore, Michael Huang has argued persuasively that these powers have always been with the tribunal. That said, I think there was considerable unease on the part of many tribunals to try and adopt summary procedures for determining claims and defenses out of perhaps undue concern that, you know, due process complaints or breaches of natural justice complaints may be subsequently raised. So tribunals, I think, tended to err on the side of caution and were very slow to make summary determinations. So to that extent, I think this rule clarifies and that this is in fact something that's quite legitimate and something that can be resorted to. And the fact that the ICC was constrained in 2017 to issue guidelines to also confirm that under the ICC rules, you know, such summary procedures are also available, I think speaks for itself.
And so I think the takeaway is tribunals may very well have the authority, both under the SIAC rules, under Singapore International Arbitration Act and otherwise, to conduct summary procedures and dismiss a claim on an early basis. But this rule, A, confirms that, and B, perhaps gives tribunals a little courage to exercise the authority that they have. Is that a good enough rule to create this fairly elaborate multi-paragraph set of provisions, which no doubt, everybody being creative lawyers, will find ample opportunity to fight about what's manifestly, what's legal basis, what's early. Is it all worth the candle?
I think it is. Very often in arbitration, the complaint is that it's actually slower because you can't get an obviously unmeritorious claim struck out. So having an express rule, if I'm an applicant, gives me courage as well to say that I'm not just asking the tribunal to exercise some kind of inherent jurisdiction that's so broad. I actually have an express basis to ask the tribunal to make a decision on this point, provided that it is a clear and, you know, meets the manifestly high threshold. So I think that it's good to have this rule. I welcome it myself a lot because it allows me to say, look, there is this other avenue that is open and it's clearly there. So we don't have to guess whether the tribunal is going to have to resort to inherent jurisdiction or not.
Other thoughts about that? Luong, other comments? Should we keep, we're revising our rules now. Should we keep Rule 29? Should we get rid of it? If we keep it, should we change it? If we change it, what should we do?
Yes, I think we should definitely keep it. Honestly speaking, I would like this kind of clause be, included in our law, in Vietnamese law on commercial arbitration, because I think it is very important to the extent that it allows us to be to go faster. I mean, to have kind of fast track procedure, and also to save money.
Mr. Luong, what about enforcement? This is not an issue that other panelists have touched on, but what about recognition and enforcement? Suppose a tribunal does dismiss a claim, for example, or a defense, say a statute of limitations defense, on the basis that it's manifestly without legal merit. Would the resulting award, where an award was made on the claim after early dismissal of that defense, would the resulting award be subject to challenge in recognition proceedings in Vietnam? Could someone?
Yes, of course. As all arbitral awards, they should be kind of endorsed by, foreign arbitral awards, particularly, should be endorsed by local tribunals to be enforceable in Vietnam. But I think if the manifest requirement is fully respected, And if the tribunal goes, very carefully, like they should, then I'm not much afraid about a court decision to lay the award, because Vietnamese courts will look at the procedure, whether or not the procedures have been respected in conformity with the law of the seat. They do not interfere in the merits or in the substantial part of the awards. So, and this is the last point I would like to add. Unfortunately, we don't have much time to see how Rule 29 is applied in reality, and what kind of real challenges Rule 29 has met so far in reality. So maybe with more time, so that we can have more hindsight, maybe we can see more clearly how Rule 29 can be improved. But its very existence at this moment, I think, is very good and very beneficial for arbitral proceedings in general.
I think that very nicely sums up the views of the panel, and it remains for me, since our time is up, to thank all of the panel members. I think there was a very thorough exposition of Rule 29, and I think we're scheduled now for another event. So thank you again, and we'll see you shortly.
Thank you. Thank you. See you again, Hope.
Thank you, Gary.